1995. He began his law practice in Dallas, Texas, and he's licensed to practice law in Texas and California. He has over 30 years of experience in law, and he's a frequent public speaker to real estate broker and agents, has been a frequent guest on local television programs, is currently general counsel to the Santa Clara Association of Realtors. Welcome.
Hello, everybody. Good afternoon. I don't speak any Chinese, I'm sorry. If I go too fast, please tell me slow down. Sometimes I talk really fast. Tell me, hey, slow down, pal. You're going too fast. I want to thank Frank Liu for inviting me. Frank is my friend and my client. I've known Frank for quite some time. One of the best real estate agents around. If you need real estate services, he's your guy. I never know when I'm going to do a talk about legal issues, because that's really what I know is legal matters. I've been doing this for 30 years. Who my audience is. I don't know. I gave this similar talk to a bunch of real estate agents and real estate brokers, so I went through and I cut out all the technical stuff that won't interest you because you're probably not real estate agents or brokers. But I'm going to talk to you today about things that are topical that's going on in the real estate market, and then at the end I'm going to talk to you about things that you can do to protect your assets. So as we go through this, I think the way I like to teach and to lecture is if you've got a question, don't wait to the end, because A, you may have forgotten it, and B, if I'm on the topic, you're going to get a pretty quick response. So if you've got something you want to talk to me about, raise your hand or just shout out if I don't see you, and then we can go and answer the question and then move on. And then when I run out of time, I run out of time. So I can probably talk for hours. You don't want to hear me talk for hours, probably. You're probably wondering, when is this guy going to stop? All right. We're going to talk about short sales. Anybody ever hear that term before? Yeah. Boy, is that, you're getting sick of hearing it, Frank. I understand that. Here's what you have to understand about the lender options. I'm looking at this from the viewpoint of the bank or the lender. What are they looking at? They have, you're upside down on your mortgage, or you're not able to make your loan payment. So what are they looking at? They can do a loan modification for you. Anybody ever apply for a loan modification? Takes forever and a day. Really a very lengthy process. I'll tell you the key to some loan modifications. I have a number of lawsuits that I filed against banks. And the most recent one I filed against the Bank of America. And I was talking to the attorney for the Bank of America, and she said, you know, I think we might be able to settle this case, but I want your client to do a loan modification. And I said, my client's already done a loan modification, and you guys rejected it. And she said, yeah, that's before you sued us. Now you've got her attention, we'll talk to you about the loan modification. But the only way the loan modification works in reality, no matter who the bank is that you have to have some type of excuse for why you can't pay. If it's a residential situation, lost my job. I've had the following, so I know these are acceptable. Lost my job. My child has to have a lot of surgery and we don't have any medical insurance, so there goes all our money. I just got divorced. I only have one payment on the mortgage, not two salaries. I got demoted from my job. I was working as a union person in San Francisco making 60 bucks an hour. My job has ended. I'm over in the Central Valley where I make $35 an hour. I don't have as much income. If you can show a hardship, I've got a card guy right now, we're talking to the bank, he's just contracted cancer. He's got cancer of the lymph nodes in his neck, and it's pretty serious. And so he can't work very often, so he can't make the mortgage payments. These things will get the bank's attention, and they might be able to do a loan modification. Now, what is a loan modification? What you're trying to do is change your interest rate usually. Let's assume you have an interest rate of 6–7% residential. It's pretty high. You can get something for 3.5%, 4.5%. So if you're trying to lower your interest rate, that the bank will accommodate you on. What they don't like to do is reduce principal. In other words, I owe the bank $1 million. How about if you take $500,000 and lower my interest rate? That ain't going to happen. So if you're looking for that, it's off the table. Sometimes if they give you some relief on the interest rate, they lower it from 6 to 3.5, they'll tack on the interest that you're not paying to the end, which may be okay. We're all looking for that time when property values go up again, right? So if we own property, then we can own property, we can sell. Who knows when that's going to be? You have to ask the expert, I don't know. Foreclosure, okay. The bank, if you're not making your payment, the bank has the right to foreclose. That means take the property back from you. And there's two ways of doing that. There's judicial or non-judicial. Judicial means you go through the court and you file a lawsuit. Non-judicial says you don't have to go through the court. You have a process that's set out in that deed of trust that you signed when you got the loan to buy the house. And the way it works in California for non-judicial foreclosure is you get a notice of default. That triggers a 90-day period for you to pay whatever you're delinquent on. During that 90-day period, if you pay the amount that's delinquent, the lender will reinstate your loan, everybody's fine, you just go on. Once that 90-day period goes by and you don't pay, they give you a notice of sale, which triggers a 20-day period. At that point, during that 20-day period, you must pay the entire amount off. That ain't gonna happen. After the 20-day period, the lender then has the right to sell your property on the courthouse steps to the highest buyer. And at that point, you've lost your property, and then you'll eventually be asked to leave because the property's not yours anymore. That's the non-judicial foreclosure. In certain circumstances, though, banks like to do judicial foreclosures. That means they sue you, because what they're doing is, what they want to do is they want to foreclose against your property and then sue you for the difference. How much the property was sold for and how much you actually owe. It's a rare occurrence. I've seen it twice in my career. It doesn't happen very often because, and we'll talk about this a little bit later, it's a very time-consuming and expensive proposition. Okay, what else can the bank do? Sometimes they'll take what's called a deed in lieu of foreclosure. Here, take the property. I don't want to go through the loan modification. I don't want to go through the foreclosure. I don't want to go through any of this stuff. I'm offering to just give you the property back. Execute a deed in favor of the bank and walk away. So a deed in lieu of foreclosure. Before the last 2 or 3 years, I don't think I'd seen a deed in lieu of foreclosure in California ever. But now I've done 2 or 3 of them. Because the bank sometimes thinks it's easier just to not mess with all of the loan modifications, everything else, I'll just take the property. Get it on the market, sell it. Deficiency judgments. In California, the general rule is once the bank forecloses on your property, that's it. They can't seek a deficiency judgment. Now, here's what a deficiency judgment means. That means if the bank forecloses on your property, you owe $400,000, and the bank takes your property back and they can only sell it for $300,000, what's the difference? $100,000. California law says, in most instances, they cannot sue you for the $100,000. I'm not going to get too technical here about what are the exceptions. But purchase money mortgage, that means a mortgage that was obtained when you bought the house. You bought the house from me, she gave you a loan, she's the Bank of America. That's called a purchase money loan. You got the loan in order to purchase the property. In California, if you have a purchase money loan, no deficiency ever. Now, seller carryback. I sell you the property and I take the paper back. I don't get a loan from a bank, I carry the paper. In other words, I sell it to you for $200,000 and I get a note from you and a deed of trust secured by your property that says you will repay me. A seller carryback note can never have a deficiency. That's another nice advantage of seller carryback. Trustee sale. If the bank sells a trustee sale or non-judicial foreclosure, no deficiency. If there's a judicial foreclosure, then they can seek a deficiency. And the problem with the judicial foreclosure is if the bank is successful in foreclosing your property through the courts, you have a 1-year right of redemption. So for a period of 1 year from the date the bank forecloses, you can buy it back from the bank during that 1 year period at the same amount they bid in. Not too bad. That's one of the reasons they don't do it. Okay, what are the benefits of a short sale? Let me describe what a short sale is to begin with. You bought your property in Milpitas for $800,000. You got a loan for $600,000 and you got a second for $100,000. So you owe $700,000. Your property's now worth $600,000. Is that a good thing or a bad thing? It's a bad thing. You're upside down. You're underwater. You can't sell it because you don't have enough money to sell it, right? You can't refinance it because it'll never appraise for what you purchased it for. So you want to get out from under that mortgage. You want to move on with your life. Maybe you're moving to go someplace else for another job. Maybe you got divorced. Maybe you're just fed up paying the mortgage. You can ask the bank for a short sale. So what you do is you hire Frank to list your property for sale. When Frank values what the property is worth, he gets an offer, and then he takes that to the bank. Will the bank accept that offer? If the bank says yes, then you continue with the short sale. And what that means is at the end of the day, the bank takes whatever they can get when you sell the property, and they don't go after you for any deficiency. If they say no, and some people think the banks have to say yes. I got news for you. They don't have to say yes. If they think they can do better than the offer that's brought to them, they're going to say no, we're not going to do that. The other thing they might do is they might look at your financial status and then they say, wait a minute. You want me to take this big hit, but I see by your financial statement that you've got $500,000 in the bank. You need to share. The pain needs to be shared between you and the bank. So they can ask you to pay, and then you can say, yeah, I am not going to pay or I will pay. 2 laws were passed in California in the 2011 legislative session. The first one said that if you have a short sale and the first lien holder agrees to the short sale, the first lien holder can never come after you for a deficiency. Okay, that's fine. But how many of us have 2 loans on our property? What about the second lien holder? So in July, the legislature said the same thing that applies to first lien holders now applies to second lien holders. So if the second lien holder and the first lien holder agree to a short sale, neither of them can chase you for a deficiency ever. Very important, because there was a lot of mix-up when the short sale process first started, and I had a lot of clients who would call me and they'd say, gee, I did a short sale, and I got this letter from the bank saying, well, when are you going to send in the $200,000 that you owe us? They had the right to do that until these recent laws were passed. Less impact on your credit score. Your credit score will get dinged, what, Frank, 50 to 75 points, remain on your credit report for about 3 years. That may sound like a lot, but it's not when I tell you what's going to happen if there's a foreclosure. Okay, short sale consequences. The cost of the foreclosure and the timing to foreclose may be a negative, because part of the problem with a short sale is the banks are inundated with short sale requests. How long is it taking you to process a short sale through the bank now?
3 months.
3 months. They can go as much as 6 to 9 months. So picture this. You want to sell your house, okay? And so you get an offer in a short sale. You give it to the bank. I'm your buyer. And I say, okay, how long is this going to take?